All right, let's try to unravel the incredibly tangled world of cybercrime law here in the United States. It's a place where, honestly, laws written back in the 80s are scrambling to keep up with crimes happening at the speed of light. So let's just dive right in.
So imagine this. You've been hacked. Or maybe you've fallen for one of those super convincing online scams. Who do you actually call? Your local police? The FBI? The real answer is, well, it's complicated. When it comes to cybercrime, the legal landscape can feel like an absolute maze.
And here's why it's so confusing. The US basically has this dual system for cybercrime law. On one hand, you've got federal laws that cover the whole country, usually for the big stuff that crosses state lines. But then you also have 51 completely different sets of laws for every single state and Washington, D.C. So the very same crime could be treated totally differently depending on where you are and who's involved.
To make any sense of this, we really have to start at the federal level with the big one, the main law that's used to go after hackers and other computer criminals.
And that law is the Computer Fraud and Abuse Act, or the CFAA. You can think of it as the foundation, really, for any federal crime that directly targets a computer or a computer network. It was first passed way back in 1986, if you can believe it, and it's been updated over the years. But it's still the government's #1 tool for prosecuting cybercrime.
So what does the CFAA actually make illegal? Well, it's a pretty broad list. We're talking about things like getting into a computer system when you're not supposed to, knowingly spreading malware like viruses or worms, launching those denial-of-service attacks that knock websites offline, and even just buying or selling stolen passwords.
To really see how this plays out, let's look at a real-world case involving a computer technician named Schuster. See, Schuster got fired from his job, and he decided he was going to get a little revenge.
Now, what's so wild about this is how he did it. Schuster wasn't some elite hacker. He just used the login details of his old company's customers, info he had from his job, to sneak back onto their wireless network. And this caused some major headaches and disruptions for the actual paying customers. So what happened to him? The consequences were pretty serious. For what he did, Schuster got 15 months in federal prison, and he had to pay back almost $20,000 to the company he hurt. It's a perfect example of how the CFAA isn't just for taking down huge international hacking groups, it's also there to hold regular people accountable for their actions online.
But of course, cybercrime isn't always about breaking into systems. Next up, let's look at crimes where computers are basically just the modern-day crowbar for good old-fashioned theft.
To even start talking about digital theft, we have to understand what the law counts as identification. And believe me, the definition is way broader than you'd probably think. A means of identification isn't just your name and social security number. Nope. It also includes things like your biometric data, like a fingerprint, your driver's license number, and importantly, even your computer passwords.
Okay, so keeping that broad definition in mind, federal law comes at identity theft with a kind of 1-2 punch. The basic crime is just using someone else's ID to commit some other state or federal crime. But, and this is a big but, if that other crime is a major felony, like wire fraud, it gets bumped up to aggravated identity theft, and that comes with a mandatory extra 2-year prison sentence tacked off. And identity theft is just one piece of the digital property puzzle. Federal law has all sorts of other tools. You've got the Economic Espionage Act, which goes after people who steal valuable trade secrets. And then there are criminal copyright laws, which are used to prosecute things like massive software piracy rings.
Okay, so we've covered the laws used to go after the bad guys. But what about you? When law enforcement starts investigating these crimes, what rights do you actually have to protect your digital life? Well, the answers to that have been slowly taking shape for almost 100 years. Yeah, your digital privacy rights didn't just pop up out of nowhere. They've been built up through these huge Supreme Court cases. I mean, think about it. Back in 1928, the court basically said wiretapping was totally fine as long as the police didn't physically trespass on your property. But by 1967, in a case called Katz, the court came up with this idea of a reasonable expectation of privacy. And more recently, in 2001, the Kylo case put limits on the government using super high-tech surveillance tools that you and I can't just go out and buy. And all of that history has led to this really critical distinction in the law. The Fourth Amendment gives you a lot of protection for the content of your communications. The actual words inside your emails or what you say on a phone call. But it generally does not protect the traffic data, what we'd call metadata. Things like the phone numbers you dial or the email addresses you send things to. Why? Because the courts figure you're voluntarily sharing that info with your phone or email company just to make the service work.
So let's see how all these rights actually work in a real, modern investigation. Take the case of United States v. Christ. The police got a hold of a computer that someone had literally put out with the trash. A private citizen found it first, saw some illegal stuff on it, and then turned it over to the cops.
Now, the police didn't just click around the files like the guy who found it did. Oh, no. They gave it to a forensics expert who used this incredibly powerful software called EnCase. And this process was intense. It created a perfect digital clone of the hard drive. It read every single file, bit by bit. And then it compared the digital fingerprint of every file against a huge police database of known illegal material.
And this process raised a gigantic legal question. When the police use technology that can see way, way more than a human ever could, we're talking deleted files, hidden data, everything, does that count as a brand new search that needs its own warrant?
And the court's answer was a resounding yes. It decided that the EnCase analysis was so much more powerful, so much more intrusive than what the original citizen did, that it was a completely new search. And this is a huge deal. It means that just because the police legally have your phone or your laptop, that doesn't give them a free pass to use every technological tool in their arsenal to dig through it. The Fourth Amendment still puts up a fight.
And that brings us to our final stop, and maybe the single biggest legal puzzle in cybercrime today, the showdown between law enforcement and encryption.
Right at the center of this fight is the Fifth Amendment. It's the one that says no person can be compelled to be a witness against themselves. To put it simply, the government can't force you to give them testimony that's going to help them convict you of a crime. This constitutional right created a massive roadblock for the government in the case of a man named Sebastian Butcher. His laptop was seized by agents at the border who thought it had illegal content on it. But when they went to look, they hit a brick wall. The entire hard drive was encrypted.
The government went to court to try and force Butcher to give up his password, but the court actually sided with Butcher, and its reasoning is fascinating. The court said that making him type in a password he's memorized isn't just a physical action, like giving a key. It's testimonial. It forces him to reveal the contents of his own mind, the fact that he knows the password and can access the files. And that is exactly the kind of self-incrimination the Fifth Amendment was designed to prevent.
And that leaves us with a really profound question to chew on. Our fundamental rights were written down more than 200 years ago in an age of paper and ink. Today, as unbreakable encryption becomes the default on every phone in every pocket, how is our legal system possibly going to balance the government's real need to investigate crimes with these ancient fundamental protections? Honestly, that's a story that is still being written right now.